Okay, here is motion number 5. We've been reading all these motions from Kyle's attorneys, and there have been 5 of them, and this is the final one. If you want to hear the previous 4, I have them in my previous videos that were recorded over the last couple of days. At any rate, here we go. Motion number 5. The state seeks to prohibit the defense from introducing any evidence that an anonymous law enforcement officer provided water to the defendant or told the defendant and other individuals that we appreciate your guys, we really do. And they have it as a misspelling here on your, which is obviously a misspelling, but I'm not sure where that comes from. The state believes the actions of law enforcement with regard to the people on the streets during the night of August 25th have no bearing on this case, and any statements are irrelevant hearsay. The state is wrong again. Hearsay is defined as a statement other than the one made by the declarant while testifying at the trial or hearing, and this is emphasized here, offered in evidence to prove the truth of the matter asserted. The defendant is not seeking admission of that evidence to establish that the officer did in fact appreciate Mr. Rittenhouse and others that evening. It is well established that out-of-court statements may be offered to prove innumerable relevant propositions apart from the truth of any matters asserted. The question is not whether the evidence might be inadmissible hearsay if it is offered to prove the truth of the matter asserted. Rather, the question is whether the evidence is offered for a legitimate reason other than for the truth of the matter asserted. Rather, this statement goes to the defendant's state of mind. The state of mind, boy, Binger loves that part. When determining whether the defendant's conduct was criminally reckless or intentional, the fact finder is to consider not only what the defendant was doing, but how dangerous the conduct was and how obvious the danger was. The fact that law enforcement, entrusted to uphold the laws of this state, made this statement to the defendant goes directly to the defendant's state of mind regarding the conduct and the obviousness, or lack thereof, of that danger. If the conduct was so obviously dangerous, it seems logical that law enforcement would have either removed the defendant from the situation via arrest or informed him that he was to leave the area because of his actions. They did neither. The fact that law enforcement made that comment to the defendant goes directly to the above-mentioned elements for which the jury will be asked to decide. And so what do you think? The fact that the law enforcement expressed appreciation for Kyle and what he was doing, do you think that should be admitted? Write in the comments below. Like my video and subscribe to my channel.